Today's webinar is about understanding the difference between security clearances, public trust, suitability, and why it's important. There's going to be some overlap here because there are some, I would say, a number of similarities, but we'll get into that in a second. So as Taylor indicated, my name is Ryan Nerney. I'm the managing partner of the Ladera Ranch office for Tully Rinckey. Just as a disclaimer, today's webinar is not intended to be legal advice. The views expressed here are mine and do not imply any endorsement by any type of intelligence community, Office of the Director of the National Intelligence, or any other U.S. government agency. Now, as I said before, today's topic of discussion is going to be essentially what is a security clearance, what is a public trust, what is suitability, and then what are the key differences between them. This is only a 30-minute webinar, so we're going to try and get as much information about this as possible. So let's move on to suitability. And I'm going to kind of go into suitability, then public trust, and then security clearances, because that's kind of the process, if you will, that everyone needs to go to, specifically for federal employees. So suitability is governed by 5 CFR 731.05. It's a regulation that is commonly cited by OPM, the Office of Professional Management, and it essentially applies to competitive service and career SES applicants, essentially federal employees. It sometimes allows appeals to the Merit System Protection Board, appeals meaning if you're found unsuitable for federal employment. Then there are some circumstances where you can appeal those to the Merit System Protection Board. I'm not going to get into a lot of that today because that honestly would be a whole nother webinar, but that is an option, again, depending on the circumstances. So there's a similar process for government contractors. They're technically different because they're called something different. Obviously, there's a suitability for federal employees. It's called credentialing for government contractors. They do have a little bit of a different regulations that apply, but essentially it's just credentialing is where you require physical access to federal facilities. Again, different from actual suitability determinations because government contractors don't actually get those. That's strictly for federal employees, but there's kind of a similar process for government contractors as well. So, and the concerns here for suitability, they can be based upon a number of things, but it really takes into account an individual's character, conduct that they may have an impact on the integrity or efficiency of the service. Again, several issues on security clearance eligibility can also be disqualifying for suitability determinations. And the suitability is done prior to a clearance adjudication. So essentially, for suitability, government agencies kind of use that suitability aspect to essentially pre-screen you. It could be used to pre-screen you to see if you would be able to get a clearance in the future or a public trust even. And it's kind of, like I said, that pre-screening to see if there would be some issues that would pop up that potentially could be a security concern. And if they are, and if there is a situation where that agency, has offered you employment, but then they later determined based upon a background investigation or what have you, that they either determine that that's not something that would positively impact the integrity or efficiency of the service, or could potentially cause you to not be able to get a security clearance. They could use that as an unfavorable suitability determination, in which case, they would probably pull any job offer at that point. Obviously, because you would be found unsuitable for federal employment. So that's kind of what suitability is. Again, like I said, it's kind of like a pre-screen to, the next aspects, which would be, public trust and a security clearance. Actually, I'm going to go to a public trust first. So public trust requires a sponsor, just like a security clearance. And typically when you do a public trust or trying to get a public trust, again, it's not a security clearance. So it's important to understand that, although the processes can be similar, very similar, In some cases, it's not a security clearance. So typically for a public trust, you have to fill out a form called an SF-85, which is a non-sensitive position. And the public trust, which is, sometimes the non-sensitive positions are considered low-level public trusts. It depends honestly on who you talk to, but the proper name for it is a non-sensitive position. And then the actual public trust itself is a high-level public trust, which is an SF-85P. So there's two forms you have to fill out depending on what level you're going to get. The SF-85P is very similar to an SF-86, which I'm going to talk about in a minute. The time frames are very similar. It just doesn't ask you as many questions as like the SF-86 does. But it's a lot more of an in-depth investigation than you would get for just a simple suitability determination initially, or a non-sensitive position. Again, as I said before, a public trust is a step below security clearance eligibility. And just because you're able to get a public trust doesn't necessarily mean you're able to get a clearance. Most of the time, if you're able to get a security clearance, then you should be good on a public trust. But again, it's it kind of depends on the circumstances. You see point number 4 here: clearance denial or revocation doesn't outright mean you'll be denied a position of trust, a public trust, but again, it will have an impact. So because a lot of those circumstances that would result in a clearance revocation or denial are also concerns for a public trust. So again, as I mentioned before, a public trust is not a clearance, but it can be granted based upon simple criminal or credit checks. Again, it's easier to obtain than a security clearance, as it's common for positions of trust such as like IT, finance. Individuals or positions that don't necessarily come into contact with classified material, excuse me, but are more akin to like sensitive information or PII. That's typically where public trust would come into play. Public trusts sometimes offer appeal options, and I say sometimes because it really depends on the agency that is either offering it or sponsoring you for it. I know in the Department of Defense there are some public trust adjudications that go through a very, very similar process to the security clearance process. They're typically referred to as ADP cases. And those would require, an issuing of a statement of reasons and going through that process. But again, it's not a security clearance. And just because you're able to obtain a public trust does not necessarily mean that you would be able to obtain a security clearance. Now, going to the actual security clearance itself, obviously security clearances are a little bit more broad than suitability or public trusts. They apply to federal employees and contractors that require security clearance or access to classified information. If anybody's ever seen any of the past webinars that I've done or that we've done, as a firm, that you require a sponsor for security clearance. You can't just get a security clearance or apply, fill out an SF-86 and, submit it to, OPM or whoever. There has to be some sort of government agency, government contractor, government subcontractor, whoever it is, that has the ability not only to sponsor people for a clearance, but also sponsors you for that. Typically, it's updated in your sponsorship is updated in something called the Defense Information System for Security, which would be on the DoD side, or for the intelligence agencies, it would be Scattered Castles. Anything like that would show, your sponsorship. But again, before you can start this process for security clearances, you need to have a sponsor. Security clearances are governed by Executive Orders 10865 and 12968. Also, there's the 13 adjudicative guidelines, which are found in the Security Executive Agent Directive, also known as the SEAD 4. And the way to start the process, which is a little bit different from public trust, is that you fill out an SF-86. That's your security clearance application, regardless of what level you're going, secret, top secret, SCI, whatever it is. A security clearance always starts with an SF-86. That's more in depth than an SF-85 or an SF-85P. They ask you a little bit more about your background. Sometimes depending on the circumstances or whatever section it is, they might expand the amount of time that you need to report. 5 years to 10 years, or 7 years to 10 years, whatever it is. So they just essentially, it's a more in-depth background investigation. And also security clearances have an interview. Most of the time now, security clearances and public trust do have an interview as part of the application and investigation process. There have been circumstances where I have seen in the past where public trusts do not have interviews, but for any security clearance you get at this point, whether, again, it's a secret, top secret SCI, whatever it is, you're going to have what they call a personnel subject interview, PSI, however you want to refer to it, where they're basically going to go through and ask you specific questions about the SF-86, your background, particular areas that could trigger one of the 13 adjudicative guidelines, things like that. As I mentioned before, the security clearance does have those 13 adjudicative guidelines. It goes A through M. I'm not going to go through all of them now because, again, that's another webinar that potentially we could do. But it goes anywhere from foreign influence to finance to drug use, alcohol use, misuse of information technology systems, things like that, that it could potentially go through. And there's various different disqualifying and mitigating guidelines that are brought up within those adjudicative guidelines, again, that are found in the SEAD 4. Adjudication of your security clearances, essentially it establishes a reasonable expectation that the person's appointment or eligibility for access to classified information would or would not be clearly consistent with the interests of national security. So again, it goes into more about the national security aspect as opposed to, for suitability, which would be, if you're essentially going to harm the efficiency of the service, or, a public trust, which again, like I said, is kind of a lower tier. You do have the ability, as long as you retain your sponsorship, you do have the ability to appeal any unfavorable determinations via a written response and/or a hearing, depending on the agency that's sponsoring that clearance. I say and/or because some agencies, I'll call out the Department of Energy at this point. Some agencies, like the Department of Energy, only allow one or the other, meaning a written response or a hearing. You can't do both. Whereas like DOD or, some of those other organizations, DHS, whoever it is, they allow both. So it really kind of depends, but either way, there is, as long as you retain your sponsorship, there is some sort of avenue to appeal any unfavorable determinations for your security clearance. So the similarities and differences between clearances, public trust, and suitability. One thing I'll say is the application. So although the applications are different for like a security clearance or a public trust, they still require you, or they're still required in order to start that process. Generally at this point, everything is going through the new system called EAP. It's a little bit different than the eQuip that they were using previously. It kind of is a little bit more user-friendly as far as that goes, but any application that you're going to fill out is going to start with that application process. And obviously you can only get that application if you have a sponsor for either one of those. Both of those are also subject to personal interviews. Like I said before, there's some circumstances for public trusts or non-sensitive positions that don't require necessarily the personal subject interview, but most of them do. And obviously for any security clearance investigation that you go through, it's going to require a personal subject interview. The regulations, I kind of referenced this before, but the regulations are a little bit different when it comes to public trust and suitability versus, public trust and clearances versus suitability. Said before, clearances are based upon the SEAD 4, which is those 13 adjudicative guidelines. Suitability is more along the lines of 5 CFR 731. Again, there's about 7 to 9 aspects under 5 CFR 731 that they really look at for suitability. They're very similar to the SEED 4. And in fact, sometimes when we're doing, some responses to these things, there's some overlap as far as the mitigation that you can utilize. But ultimately, there's a difference as far as the process goes. And as I said before, suitability, although most of the time they will allow, some sort of response, not all agencies do. They could just simply find you unsuitable and then pull the position, pull the job offer before you proceed further. It just kind of depends on the circumstances, the severity of the allegations, things like that. The adjudication process, I kind of referenced this a little bit before, but can I do both? The answer is yes and no. Again, it depends on the type of agency or the agency itself that is providing that. Like I said before, I know some agencies on the suitability side don't offer any type of ability to appeal. For security clearances, as long as you retain that sponsor, there's a due process aspect that they do have to provide you, a written response laying out the specific reasons for the denial or the intent to deny or revoke a clearance. And then, you can have an option of doing a written response or a hearing, or sometimes both. I know Department of Defense does both, but like I said before, the Department of Energy does not. So it really kind of depends on those circumstances, if you can actually do both, but there is an adjudication process for each one of these, a clearance, public trust, and suitability. Suitability first, then public trust and clearance. So essentially, like I mentioned before, if you're a federal employee, the definition that I gave previously, you have to go through a suitability determination first. Sometimes you get this information from an OF 306, it's a federal form they have to fill out if you're, going to be a federal employee. And that is filled out sometimes at the same time as an SF 86 if your position requires a security clearance as well. Sometimes it's filled out before, but either way, the agencies will take a look at that information first and then ultimately make a suitability determination. So for instance, if an agency determines that you're not suitable for a federal employment, they offer an appeals process, you go through that and they still find you unsuitable, they're obviously not going to proceed with the security clearance process. And the reason why they do suitability first is because there's a lot of overlap between, public trust or security clearance adjudications, with the same type of concerns or allegations that potentially could cause an unfavorable decision in either of those. So it's easier for the agencies anyways, if they determine that there's some sort of suitability issue first, adjudicate that. And then, obviously they can, like I said before, they can pull a job offer. You see, I have in parentheses, it's kind of a backdoor way for an agency to pre-screen you to see if you would be eligible for a clearance. And that's typically what agencies do, at least what I found in my practice, is that they do utilize a suitability process to determine if you're able to get a security clearance or a public trust before. And if they determine that you're not, then, they could either find you unsuitable or, just pull the job offer completely. So, there's similarities, like I said, as far as like filling out applications, going through interviews and things like that. But ultimately, the differences is that suitability really happens before any type of investigation into any public trust or security clearance. So it's really, like I said before, kind of an agency's ability to pre-screen you before, they go through the whole sometimes lengthy process of, having you fill out an SF 86 or an SF 85 or SF 85P and going through that entire process. So that's pretty much it as far as, the similarities and differences go. One thing before we get into some of these questions that I have, the importance of understanding this is that, a lot of people I've found kind of combine suitability with public trust and security clearances, and it's that's not the case. While there are similarities as far as like some of the allegations, that could be brought up in a suitability investigation or adjudication, could also be issues that could be flagged for security clearance adjudication. It doesn't necessarily mean anything. So, for instance, even in a situation where you're found to have been suitable for federal employment, that doesn't necessarily mean that you're in the clear. Because if the position that you're found suitable requires you to have a public trust or security clearance, then you're going to have to go through that entire adjudication process for the public trust or the security clearance to see if there is to see if there is any type of issues. So again, just because they are granting your suitability doesn't mean that you're going to be able to get a security clearance. Doesn't mean you won't be able to get a security clearance either, but it means essentially that you're not out of the woods yet. So I want to go to a couple questions that were previously submitted. One of the questions is, what's the value in the market for having a public trust or a DoD security clearance? I mean, obviously, if you have a security clearance, it pretty much opens up a little bit more opportunities or jobs, because a lot of, especially for DoD, a lot of those positions do require at least a secret level security clearance. Not all of them do, but some of them do. And most of the time, if you're able to obtain a security clearance, you should be good with the public trust. I've even had situations where individuals have been denied a security clearance and were able to get a public trust as well. So it really just kind of depends on the circumstances. But again, that kind of shows that the public trust is a little bit of a lower tier, if you will. Let's see. One question is the possibility, or is it possible to go through the process for obtaining a security clearance more than once and be successful at the end? The answer to that is yes. I mean, there's definitely a number of people who have been previously denied a security clearance, but have been able to get one later on. There is depending on the circumstances, there is a reapplication process to go through. Strictly talking about the DoD side and more specifically the contractor side. So if you're denied, and this is kind of another question as well, for the reapplication process, but if you're denied a security clearance or if your security clearance is revoked, most of the time you have to wait a period of 12 months before you can reapply. The 12-month period starts at various different times, depending on, what your job is, who's adjudicating the clearance and things like that. But it would be 12 months most of the time before you can reapply. And once you go through that process of reapplication, you have to obviously make sure you have a sponsor. You will likely have to submit in fact, it's not likely, you would have to submit a new SF-86. And that would essentially trigger a notification to whoever's holding your clearance. In this case, I'm going to, talk about DCSA or DOHA. That'll notify them that you have reapplied for a clearance after the 12-month waiting period. And before they even look at that new SF-86 that you submit, they'll essentially send you a letter that you would have to address any previous allegations that were not mitigated that essentially caused your clearance to be denied or revoked in the first place. So those would have to be addressed before they even get to the new SF-86. Looking at it to see if there's any new issues or new problems or any similar problems. If you submit that reapplication and your reapplication is denied, meaning that you weren't able to mitigate the previously unmitigated concerns, you have to wait another 12 months before you can reapply again. If your reapplication is accepted, then most of the time, if there's no new issues, you should be in the clear. But meaning the investigators and the agencies will still have to go through that whole adjudicative process. Essentially like you're starting from scratch, looking at the new SF-86, probably having a new personnel subject interview, and then kind of going through that entire process again before you can actually get that clearance. Another question I have here is, can I keep my civilian DoD job with public trust if I lost security clearance in the military? Question to that is, it depends. And it depends, kind of like I was saying before, just because you're denied a security clearance doesn't necessarily mean that you will be denied a public trust or that any public trust that you have will be revoked. It could potentially have an impact because, like I said before, there is some overlap there between security clearances and public trusts, as far as like very similar adjudicative guidelines, if you will. For that. But, like I said before, just because you're denied a clearance doesn't mean that you will be denied a public trust. I've had a number of clients who have had a clearance denied or revoked in the past, but they were still able to get a position of trust or a public trust. But I've had a number of situations where clients have been denied both. So it really depends on what the actual allegations are. And it really is a case-by-case basis in relation to that. Another question I see here is, if found unsuitable for one agency, how does it affect suitability for another? It depends, again, and it depends on the agency. Most of the time, it will have an impact because the suitability aspects are really governed by OPM. And I would say 99% of the agencies within the government are governed by OPM as well. So if you're found unsuitable for employment with one agency, and it's based upon the OPM adjudicative guidelines, you're pretty much not going to be able to be suitable for employment with another agency. That doesn't necessarily, unless you're barred from federal employment generally, that doesn't mean you can't apply for those positions. But I would find it very difficult to see how you would be able to get suitability based upon the same regulations from one agency when you were denied suitability from another agency based upon those same regulations. I think it would be pretty difficult. I think there's a few questions here that we've been throwing out. Let me see. There's a couple more. How is suitability determined if no forms like an SF-85 or an SF-86 are filled out? I touched on this a little bit, but there, for any federal position, you would have to fill out a form like an OF-306 or something like that. Typically, there's only like maybe 15, 16 questions on those forms that typically go into like past drug use, failure to pay taxes, criminal history, stuff like that they'll ask about. So they're not nearly as in depth, but for any federal employment, that doesn't require an SF-85 or an SF-86 to be filled out, they're going to get that information through the OF-306, most likely, or another similar form. And that's how they would kind of make those suitability determinations. How long should somebody wait to get back into federal government? How long should a person wait to get back into Homeland Security when their clearance was denied? Answer is depends. It depends on what the reason for the denial was. If the reason for the denial was, let's say financial failure to pay debt, and that debt hasn't been, paid off by the time you went through that investigation. If that debt's been resolved now, that's something that you could definitely, apply for. Most of the time, if your clearance was denied, like I said, you have to wait a period of 12 months. So you want to make sure that that period is elapsed before you do that. Other circumstances are kind of based upon the circumstance, right? So if you, let's say, I don't know, used some sort of illegal drug and that caused your clearance to be denied, and that illegal drug use was within a year. If you wait another year or 2 years, the longer you go without having engaged in that similar behavior, the better your chance is to get that security clearance. But again, it's really a case-by-case basis when it comes to that. The last question here, because we're getting up to the wire, is if there were security concerns that were adjudicated but they were unwarranted, can the adverse information be removed out of the record? I'm not sure what it means by unwarranted. I mean, any investigation or adjudication is going to have to be based upon some information that the investigator gets. If they were adjudicated and it was unfavorable, realistically, the only way to kind of resolve that would be is if you go through the actual adjudication process through like a reapplication or something like that. There are some circumstances where if you have some solid evidence, and by solid I mean like it's saying you were born on a certain day and you obviously have a birth certificate to disprove that. It would have to be something solid like that. You could potentially petition the organization to remove that information, but it has to be something solid like that. It can't just be you sending a letter and saying, hey, I don't agree with this, I want it to be removed, because they won't do it. So that's pretty much it. I hope I answered all your questions, and I'll turn it back over to Taylor.
Thank you everyone for joining today's presentation, and thank you Ryan for presenting. Today's webinar was recorded and a copy will be sent to all attendees early next week. I hope everyone has a good rest of their night.